Guantanamo. And then the Supreme Court explained that Guantanamo is not an active war zone, and there would not be practical difficulties with extending habeas review to the detainees in Guantanamo. In light of those remarks by the Supreme Court, we are fairly confident that the courts are not going to extend the decision to Iraq, Afghanistan, and elsewhere. But as Professor Cole noted in the Washington Post, I guess it was yesterday or 2 days ago, the issue is open, and the courts are going to have to grapple with that question as well in the coming months, if not years. Which leads us to the third question, which is what this decision means for the role of the judiciary with respect to the war-making powers of the political branches. And a couple of things. I think one observation is it is clear the judiciary will have at least some role because of these unanswered questions. The judiciary is going to have to decide, at least on a category-by-category basis, whether habeas extends to other parts of the planet. There's at least that role. But also looking at the bigger picture here, it's important to review the bidding to see where we've gotten, how far we've come. That gives us a sense, perhaps, of where the Supreme Court might go in future months and years. We start with 2004, when the Supreme Court reversed the D.C. Circuit in the Rasul case. In the Rasul case, which was named al in the D.C. Circuit, we had a unanimous decision from a panel that included Judge Garland. I think we can all agree that Judge Garland is an extremely fair and extremely intelligent judge, and he calls them like he sees them, and in this case, he ruled in favor of the government, and the decision that he joined was reversed 5-1-3 in the Supreme Court. Since then, we have two congressional enactments, as noted, the Detainee Treatment Act and the Military Commissions Act, and we have two additional decisions from the D.C. Circuit. We have the Hamdan decision, which was reversed 5-3, and then we have this most recent decision, Boumediene, which was reversed 5-4. And this, of course, is all taking place in the context of the war-making powers that and two statutes that were signed on by both political branches. And the Supreme Court also noted that its decision, at least in Boumediene, was unprecedented. So you put that all together, the unprecedented nature, the D.C. Circuit rulings, war-making powers, both political branches getting together, and nonetheless the Supreme Court decides that we were doing the wrong thing. Again, it's hard to predict what this portends for the future, but I don't think one can optimistically say that the Supreme Court is going to stay its hand. It has not been embarrassed to step in and make decisions reversing lower courts and reversing the decisions of the political branches. So again, hard to predict where things are going to end up, but at this point at least it looks like the Supreme Court is not afraid to step into this battle in the future. So those are the three issues I wanted to address. After we all speak, I'm happy to take any questions you guys have. But once again, thank you for letting me have the privilege of speaking before you today, and I hope to speak to you afterwards as well. Thank you.
Thanks, John. I think we could all agree he's done a fantastic job explaining the decision. You might wonder, what is the State Department's role with this? Because, of course, admittedly, Boumediene is not an international law decision. But I think if you look at this case, you're going to decide that there are at least two interesting international legal problems that are posed by the decision. And given the short amount of time we've had since the decision came out 2 weeks ago, I don't really have any answers to these questions, but I hope to at least start an interesting dialogue and give you a sense of what the debate has been within the U.S. government and within the State Department about the best way to respond to this decision. So the first of these issues is, what impact does the decision have on the debate that has been ongoing within the international legal community regarding the application of human rights law versus the law of war to Guantanamo? And then secondly, what is the impact of the decision on transfer litigation, seeking 30-day notice requirements and injunctions prohibiting transfer in the federal courts? Now, I think what you're going to end up seeing is that while the Supreme Court has shed a good bit of light on what it thinks about these particular questions, it has, as John suggested, let a lot of questions open. And so what's going to be developed over the course of the next year, 2 years, 3 years, is an answer to some of these issues. So to take the first of these issues, the relationship between IHL and human rights law, Those that have read anything about U.S. government detention policies in the war against al-Qaeda will know that this debate about what is the relationship between the law of war and between human rights law has been a central feature of the international legal debate in this area. Now, what I think is non-controversial is the idea that in armed conflict, international humanitarian law, or the law of war, applies as the lex specialis. But I think one of the issues that people have struggled with is understanding why it is that we've been trying to apply the law of war to what some individuals may think is not a traditional wartime situation. It's at least worth noting that if you look at the actual facts that have occurred since and before 9/11, it becomes pretty evident, or at least a good argument, that we're involved in an armed conflict with al-Qaeda. You look at the embassy bombings that happened in Tanzania and Kenya in 1998, the attack on the USS Cole in 2000, which they just announced charges, of course, against al-Nashiri with respect to his involvement in the Cole bombing yesterday, the, of course, horrific attacks on 9/11, and terrorist attacks that have continued in Afghanistan, Iraq, and in Europe. You have the declaration of war by Osama bin Laden on the United States. He's done it on more than one occasion. And perhaps most importantly, from an international law perspective, you have invocations of the self-defense provisions of the NATO treaty, the ANZUS treaty, and the Security Council recognizing that the United States was entitled to act consistently with Article 51 of the UN Charter in response to the 9/11 attacks. So despite what would seem to be overwhelming evidence that would suggest that IHL would be the applicable law in this area, we have still been repeatedly questioned on what role, if any, human rights law plays in the conflict with al-Qaeda. And our critics have argued often that instruments such as the International Covenant on Civil and Political Rights, or the ICCPR, should govern our detention operations, and they've usually made two variants of the argument. One has been, there is no war with al-Qaeda, or that war ended in 2002 with the end of hostilities in Afghanistan, and therefore we're now in a human rights peacetime world. Or second, that this vaguely defined principle of complementarity, which discusses the relationship between IHL and human rights law, applies in this situation in such a way that the ICCPR would be applicable. Well, I think the first of these two arguments is pretty easily dismissed with. I mean, there's clearly an ongoing war, at least in Afghanistan. I mean, you look at the numbers. 2008 has been bloodier to this point in the year than 2007. 2007 was bloodier than 2006. So it's very difficult to argue that there's not an ongoing armed conflict. And on complementarity, I think the U.S. government view has been more complex than that which the critics have allowed. I mean, we acknowledge that there are situations in which IHL alone governs, such as armed conflict, other situations where human rights law alone governs, such as peacetime, and other areas where both laws play, such as in non-international armed conflict or in domestic operations during non-international armed conflict. But not surprisingly, the government decision with respect to detention operations at Guantanamo was to begin with the category of IHL alone being applicable because we were detaining wartime combatants. And so the first question I think that I would like to address is, what does Boumediene tell us about whether the U.S. government is on sound legal footing with respect to our view that the application, with respect to our view of the application of human rights law to the war with al-Qaeda and the Taliban? I mean, after all, it has already been pointed out to us by some foreign observers, habeas corpus is a bedrock protection of human rights law. It's embodied, for example, in Article 9 of the ICCPR. So they say, well, if the courts are applying this human rights law concept, admittedly via the U.S. Constitution, could the U.S. be correct in saying that human rights law has limited or no application in a location like Guantanamo? Well, does the decision tell us we were wrong not to apply human rights law treaties to Guantanamo? I think the answer to that question is no. I mean, putting aside the fact that the decision was a constitutional decision and not a treaty-based decision, the reality is that we actually have separate, long-standing legal interpretations that explain the reasons why human rights treaties do not belong in a place like Guantanamo. For example, Article 2 of the ICCPR limits its application to all individuals within its territory and subject to its jurisdiction. And we have consistently interpreted the phrase "and" to mean what it says, and only apply in situations where the treaty is in the territorial United States